Hello, I'm Adam Kielich, the principal attorney at the Kielich Law Firm in Bedford, Texas, where I help clients in the Dallas and Fort Worth area with employment law, family law, consumer law, and other litigation needs. Today's video is going to discuss the Texas Deceptive Trade Practices Act. We're going to answer the question, what is the DTPA? To answer that question, we'll first begin with a brief overview of the statute. Second, we'll talk about what kind of claims can be brought under the DTPA. And third, we'll talk about the remedies available under the law. Just to be clear, rather than saying Deceptive Trade Practices Act, from here I'm just going to refer to it as DTPA. But let's get into an overview of what the DTPA is. So the DTPA is a consumer law statute that gives consumers remedies for unfair, dishonest, and outright fraudulent business practices directed at consumers. The DTPA is not the only consumer protection law under Texas law, but it's probably the most effective because it's wide-reaching and it gives consumers really powerful remedies. Consumers have other options to bring claims under other statutes and common law claims like breach of contract. But most other statutes have more limited remedies for the consumer. And many of the common law claims like breach of contract can become incredibly complicated. And it's very easy for a consumer plaintiff to lose a breach of contract claim or to not get the kind of remedies that they really deserve for the claim because of the complications that come along with just dealing with common law claims, and especially with breach of contract. The DTPA streamlines a lot of that. It makes it easier for a plaintiff to win a claim, and when a plaintiff does win, to recover a greater value from the defendant. Part of the role of giving plaintiffs such large remedies under the DTPA is to act as a deterrent to businesses from engaging in the deceptive trade practices in the first place, and second, as a deterrent from pushing the plaintiff all the way through an expensive trial just to get to what the defendant already knew they did wrong. And so it encourages settlement early on in the case to avoid the plaintiff going to trial and getting a substantial judgment against the defendant. So let's talk about what kind of claims can be brought under the DTPA. Broadly, the DTPA prohibits deceptive practices in the selling of goods and services to consumers. It applies to almost all consumer transactions. There are a few that are explicitly excluded from DTPA, but actually can still be brought under DTPA if the defendant fails to raise a defense that DTPA excludes these claims. Within the statute, there are some broad categories of claims that can be brought, and there's also a long list of specified practices that includes certain types of activities and specifically captures certain industries like insurance and debt collection. These are known as laundry list violations. There are also a number of other consumer protection laws that are allowed to tie in with the DTPA. And so, although the particular consumer protections under one statute do not carry the same kind of remedies as the DTPA, the consumer can actually invoke the prohibited practices under one statute but obtain the remedies available under the DTPA when these are tie-in statutes to DTPA. And these are all specified within the DTPA itself. But by and large, the DTPA is going to apply to transactions that include really any kind of deceptive activity, whether it's deceptive advertising of a product, turning over to a consumer a product that is not what they paid for or what they agreed to purchase. It includes failing to honor warranties that are sold on products. And similarly, it applies to services sold to the consumer when the services do not meet the standards of what the consumer paid for. DTPA is specific to consumers, though, and under the statute, this applies to any transaction involving an individual or a business with assets under $25 million when that's the plaintiff. It doesn't matter who or what the defendant is for the most part. They don't have to meet this consumer definition, only the plaintiff does. And if the plaintiff does meet that definition and is a consumer, then we turn and look to the allegations of the deceptive practices and whether they meet the statutory definition as deceptive under either the laundry list violations, a tie-in statute, or the general provisions of the statute that prohibits these deceptive practices. And so for the most part, the DTPA is going to apply to a claim that relates to a consumer transaction when the consumer paid for something and the seller did not deliver what was paid for or what was advertised to have been paid for. If you find yourself with a DTPA claim, then you've got to figure out what kind of remedies can I get under the statute. Does it make sense to even file a suit? What can I do here? And so the remedies are extremely powerful under the DTPA. As I said before, part of the reason why the remedies are so outsized for most types of plaintiff claims is that it's really intended to act as a deterrent from the deceptive trade practices in the first place, and second, to encourage the business to settle with the plaintiff early on, maybe even before litigation begins. So generally under the DTPA, a consumer is going to want to recover monetary damages to be made financially whole for a bad transaction. And so what a plaintiff can recover is first, whatever normal relief would be available under other similar claims under common law. And specifically, we tend to look at breach of contract type remedies. And these include things like the loss of use of the property, the difference in the value, the replacement or repair cost for the property, or other types of relief for the failure of the seller to provide the good or service as it was intended, or what the consumer thought they were purchasing. Now, that doesn't mean that the consumer can get all of those, but the consumer can pick whichever formula of those types of damages and ask for the court to award that. Additionally, if the consumer can prove that the violation of the DTPA was knowing or intentional, then the plaintiff gets to triple that amount, what's called treble damages. So if, say, the difference in value between what was purchased and what was actually received is $10,000, and the plaintiff can prove that the seller knew there was a difference, instead of just getting $10,000, the plaintiff can actually get $30,000. And so that's a good jump in cash. But again, the plaintiff has to prove that the seller was aware of or intended to defraud the consumer in giving them the wrong product. If you go out and purchase a car and it's supposed to be a V6, and by accident they give you the keys to a 4-cylinder, and it's an honest mistake, if for whatever reason they won't swap out the cars and give you what you want, you would have a violation, and you could recover the difference in value between the 4-cylinder and the 6-cylinder, but you probably would not get treble damages just because their action was accidental. In addition to recovering for the actual harm and maybe the treble damages as well, A consumer can also recover attorney fees from the seller, and so that can help cover the cost of hiring an attorney to go out and handle this professionally for the consumer. They can also recover the cost of court and other costs related to pursuing these claims. So in these DTPA cases, sometimes the actual loss to the consumer can be fairly small, but when you tie in the treble damages and the attorney fees, then you can actually end up with a judgment that's substantially larger than the initial loss. And so with that calculation readily apparent within the statute, it's an encouragement to defendant sellers to go ahead and negotiate and settle early so these attorney fees are not accruing all the way through a trial. Instead of, or sometimes in addition to, monetary relief from the court, a plaintiff can also ask the court to order the other party to take or refrain from taking certain activity, what's known as injunctive relief, or sometimes as equitable relief. This can be useful when money really doesn't make the plaintiff whole, or some combination of an order plus money will make the plaintiff whole. This is common often when a particular item is purchased and it's a rare item or it's a hard item to source. In that regard, the plaintiff may not want the money for what that product or good is worth today, but instead wants the actual product or wants it to be able to sell it somewhere down the road. A good example here might be a piece of art or a baseball card, some sort of collectible that the plaintiff really isn't made whole by just giving them money for the market value, but they might actually want that product to enjoy the product as it is. Maybe they want to hang that painting up on the wall. Or alternatively, they may be buying it for a speculative purpose that piece of artwork is going to hang up on the wall for a couple of months, but then they're going to find a buyer to sell it and make a lot more money. Well, it's hard to prove what that speculative value is going to be to the court, and you don't want to get into an argument over the speculative value in court when you can just ask the court to order the seller to turn over the property and turn over the painting to the plaintiff. That's going to be the easier route. So plaintiffs do have that option available as well. And in addition to being able to collect these additional monetary damages, the DTPA also gives plaintiffs powerful remedies to go collect judgments. Plaintiffs have some effective remedies or effective tools to collect a judgment under any kind of judgment. And given certain activities have occurred, sometimes these greater tools are made available to other plaintiffs. But under DTPA, the strongest tools available to collect a civil judgment are made almost immediately available to a DTPA plaintiff who can go out there and really try to collect from a business that's already proven itself by the court's judgment to be deceptive in the way that it treats people. And if they're deceptive in dealing with unknown consumers, they're probably going to be deceptive about paying off a court judgment and try to hide assets. And so the statute recognizes that and gives plaintiffs some extra help getting paid on the back end. And of course, in addition to DTPA, a plaintiff can always bring other types of claims. And so it's very common to see a DTPA case brought with other statutory claims, and in particular, lots of common law claims like breach of contract, breach of warranty, negligence, fraud, these kinds of things. So DTPA is not an exclusive remedy that prevents a plaintiff from bringing other claims, but it is worth pointing out, like any other civil lawsuit, that a plaintiff can only recover once for any particular set of facts. So if you bought a car and the car they gave you was not what you purchased, you could bring a claim under DTPA, you could bring a claim for breach of contract, you could bring a claim for fraud. And so although you have pled all of these claims to the court, ultimately the court is only going to give you a judgment for one of those claims. If you have maybe an actual loss of $10,000 on the car they gave you, you can get that $10,000 under DTPA or breach of contract or fraud, but you can't get $10,000 under each of them. So you're probably going to want the court to award damages under whichever claim gives you the greatest number as a whole, and that's likely going to be DTPA. But it may make sense to plead multiple claims so that if something goes wrong with the DTPA claim, maybe you pick up breach of contract and run with that, or fraud, or whatever you have. So that's a really narrow, basic view of the DTPA and what it covers. If you believe that you've suffered a deceptive or fraudulent act as part of a consumer transaction, you really should talk to an attorney about your potential claim. Let the attorney review that and make that determination. Consumer attorneys tend to know what kind of tie-in statutes are out there, what the laundry list violations are, and what kinds of things can be brought under DTPA. And it makes sense to do that because DTPA allows you to recover attorney fees from the seller, which means you're not going to be fielding the cost of an attorney and then find out in the end that even though you won your case, you're still out what you paid your attorney. I mean, at least under normal circumstances, you expect that the judgment will include that attorney fees portion, and then the attorney is going to get paid either directly in accordance with the work that was done, maybe on an hourly basis, or the attorney is going to take a contingency portion, and that attorney fees component of the judgment is going to help offset that. So it's really okay. I guess you can't be too surprised that an attorney is telling you to go talk to an attorney, but like I said, the statute contemplates that you should go talk to an attorney, and that's why it gives you that option to recover the attorney fees. So it's certainly better than trying to take your hand at litigation against a company that may be prepared for these kind of claims. You may not be the first person that they've dealt with. They may be quite the experts on defending these kinds of DTPA claims. But as a whole, that's really the basis of the DTPA. There's plenty of information online. You can find more information on my website. There'll be a link below in the text under the video if you want to look for information there as well. But like I said, depending upon wherever you are, really go talk to an attorney that deals with DTPA claims. Let them assess your claims, and if you've got a good claim, let them help you out with it. I think that's pretty much it for this video. I will probably try to put together some more videos exploring some of the more complicated details of DTPA that were not covered in this video. Maybe stream them together as a series. But for now, we'll cut off this video here, just introducing the DTPA. As always, I hope you found the video useful and that at least some of the information was helpful to you. If it was, leave a comment, like the video. If you thought the video was garbage and you hated it, that's okay. You can comment or give it a dislike. That's cool too. At any rate, again, hope you found it helpful though, and thank you for listening, and I'll see you next video.